May I please, your lordship?
You are supposed to move an amendment application.
That has already been filed, your lordship. It has not been tabbed.
It's not been done. Call the application.
And moreover, your lordship, that is my wife. She is suffering from some tumor and
You
all.
want adjournment?
I want an adjournment, a week's adjournment.
Mr. Tulsi submits that he has already moved the application for amendment in the pleadings of the petition. They receive exactly the same with the record and list the matter after some vacation.
Oblige, your lordship. My lord, I beg to mention a writ appeal, my lord, on 28, my lord.
Listing,
Listing, my lord.
listing, fresh matter.
Press matter.
Tomorrow, get the listing tomorrow, not 28.
Lordship, Oblige.
Listing a transfer matter.
Arising out of CAT judgment.
No, from the learned single judge, in fact, Justice Barwas. So this bench may not be able to take up any other.
Tomorrow, day after tomorrow, 30th, when we want?
Day after tomorrow.
Day after tomorrow.
So similar prayer lordship for a listing lordship on Wednesday. It's a writ appeal. I filed a press writ appeal lordship.
All right. Tomorrow, not Wednesday. Tomorrow or 30th, whatever is convenient.
38th then lordship.
30th.
My lord, a fresh writ appeal, my lord, I'm praying for listing on 30th.
When was the judgment passed by single?
My lord, 29th of May, my lord.
May. So now we are
My lord,
making up at the last moment.
my lord.
30th.
May I please watch? Actually, I'd like to mention newly filed writ petition for listing worship.
Writ petition. What is it about?
Worship, it's relating worship DRT matter, worship. Debt recovery matter, worship.
Debt recovery.
Worship.
30th. All right.
Daily list for orders item 2.
Council for the appellate has not taken steps for the respondent number 7. Need will be done within 2 weeks whereafter process be issued.
Item number 3.
But in this matter, we have taken steps on respondent number.
Rule is made redundant in 4 weeks thereafter. Yes.
We have taken steps on respondent number 9 on 20th of May.
Is the president. Yes, Mr. Gogoi.
If you for the health department, my lord.
So the director of medical and health is the chairperson of the respondent number 9.
I
As
can,
per the-
otherwise, my lord, I can intimate them.
Mr. Gogoi,
My lord.
submit that he has, he would be appearing on behalf of the respondent number 9 as well.
Lord.
The service is complete. Affidavits on behalf of the respondents be filed within next 4 weeks.
My lord. Oblige me.
Next, respondent number क्या?
Respondent number 6. Regarding this.
Item number 4.
My lord, in this matter, I have entered appearance on behalf of.
This is for admission of Mukut. Item number 3 will go for admission. The matter will be listed for admission. Yes.
Lord, in this matter, I have entered appearance on behalf of respondent number 6, my lord.
1,
pray
3
for
and
some-
6. 1 and 3 who would be appearing for 1 and 3. 4 we know. Who are appearing for 1 and 3. State of Assam. Agriculture. Chancellor Assam Agriculture University. That is the governor. That's a formal respondent. Former, yes. Standing Council Agriculture Department. MS Standing Council Agriculture Department, Government of Assam, puts in appearance on behalf of the respondent number 1. The respondent number 3 is a formal party. Mr. Indranil Chaudhary, senior advocate, puts in appearance on behalf of the respondent number 6.
6.
The service is complete. Affidavits on behalf of the respondents be filed. If so desired, be filed within the next 4 weeks. List thereafter. For admission.
Item number 5.
My lord, in this case, my lord, notice has been issued.
Lordship, here in this matter, I am yet to receive the instruction, Lordship.
Who would be appearing for response numbers 8 and 9?
Oh, Lord.
Who is the standing counsel for the election commission?
Election Commission.
Officer would be the divisional commissioner.
Lordship, R. Dubey, he will be representing. Lord.
R. Dubey
Yes, Lord.
will be appearing for the response number 8 and
Assam,
9.
yes, Lord.
MSM Bhattacharya submits that Mr. R. Dubey advocate is engaged, is engaged as a standing counsel for the election commission.
Yes, Lordship. State
Assam.
Election Commission.
Thus, counsel for the petitioner to effect service on such respondents, response numbers 8 and 9 by providing copies of the writ petition to Mr. Dubey, whose name shall henceforth be reflected in the cause list. Service is complete, list for admission after summer vacation.
Lovely.
Meetings be completed in the month.
Yeah, fine.
Can someone call Mr. Dubey once? So we can know that he is appearing. Give him a call, he should come and sit.
Lordship, Lordship, I shall.
Item number 6.
My lord, in this case, service is complete. Lordship may fix it, my lord, for admission hearing, my lord. My lord, otherwise dispute. My lord, my civil suit now otherwise become frustrated. My civil suit otherwise become frustrated, my lord, because the writ court has interfered with the subject matter, my lord.
Yes.
That is the core issue, my lord.
Lordship, my senior is out of station due to on the occasion of.
Service has been effected on the respondents.
All respondents repented.
This is not maintainable. Electric connection. Why should we? Chamaria,
My lord,
this is an electricity connection, essential amenity.
my lord,
How can you
my
deprive?
lord, my only saying is that, my lord, nothing, my lord. It is essential, but they could have approached before the learned civil court.
Could have, that doesn't make a difference.
My lord, how is
This is equitable writ jurisdiction.
absolutely,
This is
my lord, only one point.
prime example of requiring exercise of writ
Lordship,
jurisdiction.
even the judgment which has been relied upon, my lord, that is Dilip through versus Satish and others, it itself says the party has approached before the civil court, my lord.
Shivnath Singh's judgment, our judgment.
My lord, no doubt. My lord, question is that, my lord, if alternative, even my lord,
All
alternative-
right, then we'll list your appeal for hearing in due course then.
my lord, admission.
The
my
writ
lord,
petition has been
admission,
admitted.
my lord.
Respondents are duly represented, thus list for hearing in due course.
My lord, admission here, my lord, kindly, my lord. On that,
Admit
day,
all- We have admitted, Mr. Chamaria. This is just an academic
my
exercise.
lord, lordship know that it will, my
Due
lord.
course, there's nothing, just a frivolous writ appeal, Mr. Chamaria.
Lordship may pray only one thing, my lord, can it be fixed for admission on that day, my lord? It may
This has
be-
already been admitted
My lord,
on the last date.
Item number 7.
deeply, my lord.
No, the orders have been complied with. I have given proof of payment to the petitioner. and my
What do you say?
Lordship.
Mr. Mazumdar submits that the order under contempt has already been complied with and the payment, due payment has been made to the petitioner. He is placed on record communication forwarded by the Director of Elementary Education Assam in affirmation of the above submission in view of the above position, based on contempt petition is disposed of, rule is discharged.
Obliged.
Item number 8.
The service is complete, my lord.
Service is complete. All right, no one puts in appearance. There is a report of service.
I filed the affidavit, my lord.
Service has been effected on the respondents. No one appears on their behalf. This interlocutory application has been moved by the appellant herein, seeking condonation of delay of 13 days occasion in filing of the associated appeal. We have considered this submissions advanced by Ms. Gupta and have gone through the grounds set out in the application. We find the reasons assigned therein for explaining the delay to be germane. Hence, the application is allowed. Delay is condoned. Registry shall number the connected writ appeal list same for admission after summer vacation.
Item number 9, along with the item 19.
Please, your lordship. My lord, in this case, my lord, I am appearing on behalf of the private respondent, and we have filed an IA,
2263,
my lord,
yes.
1724.
Mm.
My lord, for vacating the interim stay against us, my lord, we have taken two grounds, my lord. One ground is that, my lord, we have filed IA for early hearing. That case has been listed before lordship, and they have made submission during mentioned time. And so I
Got it
submitted the
adjourned.
adjournment slip. Lordship will find at page 29
Hmm.
of annexure A, my lord, annexure D.
Hmm.
The learned, it is the order dated 3/3/2023. Learned Standing Council Education has moved an adjournment slip. The other side has no objection, my lord. We have not endorsed any no objection, my lord, and it was behind our back during mentioned time, my lord. Then, my lord, the case has been again.
Where were you? Why didn't you appear on that day?
My lord, it was done during mentioned time.
But then you could have instructed
My
the
lord,
courtmaster.
My lord, we arrived, my
That is
lord,
not the
we have
procedure.
a,
You could have told the courtmaster on the
we
very
have told, my lord, we have told, but I have been advised to make
So you could have.
make an application for further
You
listing,
could
my
have-
lord. The
you could have
according,
made
my lord, list, the case was again listed.
You could have
And-
made a request to the court on the same day that we have not given any no
Yes,
objection to the other
Yes, my
side.
lord.
Anyhow, argue now.
My lord, then again it was
We have
listed.
seen there are 4 or 5, 3 or 4 order sheets.
Oh, yes, my lord.
Wherein the-
Behind our back, my lord. No objection we have endorsed, my lord. This is our submission on their conduct, dealing the matters, my lord. Now, my lord, the question of seniority is in this dispute, my lord. I am a senior most subject teacher appointed in the year 1999. And I was promoted, I was allowed to act as an in-charge principal by order dated 10/10/2017. Lordship will find at page 39.
Principal in charge.
Yes, my lord.
Yes. Then what
So, my
happened?
lord, he was the appellant. Appellant was appointed in the year 1990 as an assistant teacher. And then he was promoted to the post of vice principal by order dated 13 January 2022. So my submission is that my lord, for cadre seniority, cadre seniority as per rule 2009, I am the in a class 1 category, my lord, teacher. And he is class category, my lord, he is class 3 category teacher under the 2003 rule, my lord. And he is, my lord, promoted in the year 2020 as a vice principal. So, my lord, as per rule, both he came to my cadre in the year 2020 only. As per 2009 rule, and in 2000,
Yes.
as per 2020 rule, my lord, I am also I being a postgraduate teacher, I am in this senior cadre, and he is brought to my cadre only in the year 2020. So, my lord, in both way, my lord, both as per 2009 rule and as per 2020 rule, he is not, he cannot claim seniority over me, my lord. That is the submission before lordship, and I have, and the order by which he has been promoted, he has been allowed to act as an principal in charge by order dated 37 annexure G2 in my petition. I was relieved, and he was allowed to take the additional charge of principal. This is an ad hoc arrangement. I was appointed on ad hoc arrangement. I was continuing since 2017, and he is allowed to act, replacing me, relieving me in the year 2020. That is also an ad hoc.
Where is the order?
Arrangement.
Which is the order you are referring to?
My lord, at page 37 of my application. In the interest of public
Mr.
service.
Mazumdar, why don't you direct the authorities to hold a regular selection for the post? Why it is not being done?
And this actually falls under the Karbi Angla Autonomous Council. No, this falls under the demand. 125.
This is the order. Same on the 30th June. I don't know how many places they have done that. So you are basically agreed by the order dated 30th June,
My lord,
but he holds the post of vice principal.
my lord, he is made vice principal in the year 2020.
But the vice
And
principal,
I am working prior to that.
working as an interim arrangement, what is your cadre post? On what post are you working?
Cadre post is subject.
Subject teacher. So obviously, a principal is senior to a subject teacher. You can't dispute that.
My lord,
Is he-
my lord, prior to that, I was appointed.
Appointed and on ad hoc basis. Now they have appointed a senior person on the post. How can you be aggrieved?
My lord, he is not senior. My
Senior-
lord. My
He
lord,
was.
He is in. He's
Just
junior
let us,
cadre, my lord.
Mr. Council,
I
let
was-
us know. In the cadre, vice principal is a senior post or not, as compared to subject teacher.
My lord, I was prior to that, my lord, 2000.
Is a regularly selected vice principal.
He is not a regularly selected, my lord, in the post of principal.
What
my
is
lord.
his cadre post? What is his position?
He is a regularly selected vice principal, not a regularly selected principal. That is what he's trying to say.
He says that no, he is not even a regularly selected vice principal.
No, he's a principal.
Is the respondent, is the appellant as per you, a regularly selected vice principal or not? Is he there?
My lord, I am, my lord, the vice.
You were
principal,
just
the
allowed to
post-
work as an ad hoc vice principal. But basically, your position in the hierarchy is of a subject teacher. So can a subject teacher be preferred over a vice
My
principal?
lord, principal, vice principal and the subject teacher of same cadre. They
Let
are,
us see that. Let us
My-
see.
my lord,
Where are the rules?
my lord, kindly have a look, my lord, to the 2000.
Lordship will have page 61. 61 of the book.
Yes, hold
Classes and
on.
cadres. Class 2, rule 3, B, class 2,
61.
page 61. Rule 3, B,
Mm.
Assam School Service Senior includes the cadres of vice principal, postgraduate teacher and subject teacher in vocational subjects and headmaster.
Mm. So this is a class 2 post. Both are class 2 posts.
Both are class.
So they are on the same rung in the hierarchy.
My lord,
When he was appointed in 17, what is the reason to pick up a person who is junior to him and appoint him as a vice principal? Yes, Mr. Purkaz.
Lordship will find.
Are you defending? You are defending on behalf of whom?
No, I had appointed the respondent in the post of.
What is the reason?
I had-
What is the reason to remove him? Remove this respondent. Let us know.
The repetition was not allowed on
Yes.
two grounds. One, that the respondent did not have a particular experience as a graduate teacher. That part was wrong, my lord. If lordship kindly has.
Mr. Mazumdar,
Page
let us
67.
know on the criterion of seniority, who is senior?
Well, to our calculation, he's the senior.
How is that so? When was he born into the, when were the two born in the cadre? Let us see the dates.
Well, let him point out. this
All right,
seniority basis.
that's why we asked you that you better take a back seat.
My lord,
Yes.
I was appointed in the year 1992
Yes,
And
and
he
when was the respondent
and
appointed?
he was appointed in the year 1999. The rule has changed. Earlier rule has been repealed by the government, my lord, in the year 2020. And
Yes,
after repealed, my lord, I've been, as per the existing rule, I am the senior most qualified. Because page 67 of the existing rule, which says 17 years of service as graduate teacher in any government higher secondary school is a qualification for promotion to the post of principal, my lord. As per the existing service rule, I am the senior most qualified person to hold the charge. That's why they
you are
have
reading page number
67, my lord.
67.
Yes, lordship. clause 3C. 12, rule 12, 3, sub-rule 3, clause C.
Oh, this is promotion, regular exercise. This was an ad hoc arrangement.
Ad hoc arrangement.
Then-
Ad hoc arrangement, my lord, as per existing settled position of rule, my lord, it should be as per the relevant rule. Relevant rule means, my lord, the rule in existence. As per Jagannath Pegu, my lord, there is a settled principle is there. As per relevant rule, I am the senior most qualified person, and her position.
Where is the gradation list?
Yes, my lord. And
Let us see.
gradation list, her position is 108.
Let us see. Let's see.
And it is not annexed with the, my lord, their case, my lord. It is, I have annexed in my miss case 18540.
Give the file, please. The finding of the learned single judge is at para 8. Therefore, as the respondent number 6 is not found to fulfill any of the essential criteria as prescribed in rule 12.3 and 12.3b. Now, what is the reason for this?
And this honorable court granted stay order, my lord, considering that the learned honorable single judge, while taking into consideration the rule, has not taken into consideration the rule 12.3C.
12.3c.
That's why this honorable court granted the stay order, my lord. Page 57. And the as per the gradation list, my lord, gradation list, my lord, I have annexed with this IN 1840, page number, my lord, 34, serial number 108, her name.
Just 134. Just let's see. Page number
34, serial number 108, my lord.
108 is the respondent.
Yes,
And where is your name?
my name is, my lord, page number 26, 26, my lord. Serial number 3, my lord.
Serial number 3.
Yes.
My lord.
Oh,
This
What
is
is-
my lord, different category post. He is separate.
how
my
is
lord.
the different category? Sir,
My
this
lord,
is the
this is-
gradation list.
My lord,
of the same category
is,
of
my lord, this is the
person.
list of vice principal. How these two posts may be categorized in the same category, my lord.
That we have seen the
Rule says-
rule. It's class 2 post.
My lord, class 2 post as per definition, we are of same category.
Then
But this category of the post is
but you
different.
were
my lord.
never appointed as a vice principal, sir. That was an ad hoc arrangement. Sorry.
I was appointed as a principal, my lord.
We'll hear you hear the appeal finally. No ground, dismissed 2263. You want us to make observations based on seniority list?
My lord,
Hmm.
my lord, my lord.
Do you want us to make any observations right at this point of time?
My lord,
based on the gradation list?
If the lordship has is taken up your hearing, my lord, and
Not
can
today,
already date.
not today.
My lord, I'm agree to that, my lord. If
So then all right,
case is taken up,
What do you want?
I have filed the
What do you want us to do with your application?
My lord,
You want us to decide
yes,
on
it may be
merit?
taken up hearing, taken up for hearing along with the main case.
No, absolutely no. Do you want us to decide on merits or do you want to take a decision yourself?
My lord,
We'll decide the application,
my lord,
not keep it pending.
my lord, I have raised some points, my lord.
So all right, then we'll decide all those points. Let us know, argue. It may prejudice your appeal, you can rest assured.
My lord, my submission is that I was functioning as an in-charge principal since
Are you sure?
2017.
Are you sure that you want us to make these observations, record these contentions and give our opinion in the IA?
No, my lord, then my lord, main case may be here, hard, my lord.
So then what do you want us to do with your IA? Do you want to withdraw it or you want a disposal on merits?
Yes, I may be allowed to do it. I may be allowed to do, but I have not filed any affidavit to their appeal, my lord. It may be taken up as an affidavit in opposition to the appeal, my lord.
What?
This IA,
Why file an affidavit if you want to do that?
my lord, okay.
Then counsel
I'm
Mr. Ali, we have liberty to withdraw the interlocutory application, number so and so. Hence the same is disposed of. Lord, that will be automatic, sir. Because 6 days difference. That order continues automatically. The interim order, that is already continuing, sir. The interim order that so and so shall continue. The passed in writ appeal number so and so shall continue till disposal of the appeal. The automatic consequence of Automatic consequence. Interim order gets confirmed. In view of the fact, is able to withdraw the interlocutory application filed under Article 2263 of the Constitution of India, seeking vacation of the ad interim stay order granted in favor of the respondent number so and so. In favor of the appellant herein. Appellant in rate appeal number so and so. First of, thus the interlocutory application is disposed of as withdrawn in view of the fact that the application for vacation of stay order has been withdrawn, the ad interim stay order passed in favor of the writ appellant shall is confirmed to last till disposal of the appeal. The appeal shall be listed for final disposal on 8th August. Counsel for the respondent number so and so may, if so desired, may file affidavit on behalf of such respondent in the writ appeal. What is the IA number so and so filed by the appellant seeking extension of the interim order is also disposed of. Leave love.
Item number 10.
May I please, Your Lordship? So the issue that comes up before Lordship's consideration is in the public distribution system that is prevalent in Assam. Now, what had happened is earlier,
We suppose we have admitted similar appeals.
other matters have been.
All right, this also will have to be admitted.
I've annexed the similar order at page 84.
I admit issue notice. The respondents are are they represented? All respondents,
No, Lordship, private respondents are there.
service upon the
So
comment
why-
respondents be affected by providing copies of the appeal to concerned standing counsel and counsel for the appellant to take steps for effecting service on the private respondents within 7 days thereafter process be issued. Connect with so and so.
Oblige, Your Honor.
Writ appeal number
12
12 oblique 23.
18.
18.
18.
18. There are more appeals in 23 also. PDS system.
Item number 11.
May I please, Your Lordships? My lords, we are pleased to condone the delay in the matter, my lord, on the last date. And my lord, the private respondents did not appear in the matter
Again,
despite service.
Same exercise. We'll have to admit your appeal. What else?
My lord,
Because they didn't appear in the controversy. They are again publication. So we'll straight off direct notice by publication. Or you want to undertake
I leave
the
it to
same
your
exercise
lordship.
again?
Lord,
No,
this
that's
will-
your
because-
choice.
my
It
lord-
will not happen, that is for sure.
my lord, I would have liked to serve them personally, my lord, but the problem is that the addresses which they gave, even in the writ petition, my lord, there's no detail regarding where they stay. Just they mention the district. That's all, my lord. So
We
carrying out
understand.
Service will be very difficult, my lord.
We understand. So
And we have in fact doubts whether most of these landowners
exist
are
or
still
not.
there. Yes, my lord.
that's really questionable.
In 2009, my lord, the draft award was passed.
You paid that 4 crore rupees already.
My lord, I
That
have not,
4 crore rupees has been paid or not?
no, my lord.
No.
I've asked for stay, my lord, of the learned single judge's judgment.
Mr. Counsel,
My lord.
see, the award was passed in 2009.
Yes.
Now you have not challenged that award.
My lord, I was not put on notice till 2017, my lord. The writ court, Milord, when the writ was filed in 2015 by the landowners, Milord, for the first time. Before that, there were 3 rounds of litigation before the reference court. First by
No,
the,
that I understand.
yes,
But I am saying that
Hello.
award was passed in 2009
yes,
and that has been published also subsequent thereto
yes,
in 2009 itself.
yes.
It is only in the month of August 2009, the reference court passed the order
Award,
wherein it says that 4 crores plus the 23 1A
1A and 2,
interest and 23-2 has to be given.
absolutely.
Now, against that, the non-payment was there for which the matter went to the writ court,
My lord,
and the writ court had particularly, and you had challenged that initially,
Milord,
that you were not a party out there.
yes. I
and
was
as
never
such,
a
you were
party.
remanded
Even
back.
In the reference cases, I was not even made a party. Even MHA was not made a
What
party.
about the original award, Mr. Buchan?
Milord, the award
Question
is
is original award, you are not agreed.
draft award, Milord. I never challenged it. I came to know about it only in 2017, Milord. And then what the learned single judge did, Milord, my Lord Justice Pathak, he relegated the matter to the reference court again. And the reference court, for the first time, rejected their case, Milord. They said that the reference
That
is
is
not.
only as regards the reference.
Yes.
The reference
award
was there, but what
stands.
about the award?
I'm
The
not
award
on record.
remains.
The award as on date, Milord, has not been challenged by me, Milord, because I could not have. And that is precisely my stand against them.
And the government had passed on the money to you. That is also an admitted position.
That is, Milord, I have stated that on affidavit and I have
You
used
used it for different
other
purposes.
Yes, Milord.
So
Yes.
that can't be permitted.
The Lordship, as far as Lordship knowledge is concerned about a draft award, Lordship may kindly peruse page 176 for a second, Lordship. Page 176, this is a writ petition that has been filed before the Isle bench. Page 176, para 6 here, Lordship. May I read out your para 6, Lordship? The respondent number 3, White so-and-so, had furnished the draft award number 1-2009 duly approved by the government to the respondent number 5. And a request to deposit rupees so-and-so crores only within May 2009. Then Lordship, in this case, the affidavit has been filed by EPIL. The Lordship may kindly peruse the affidavit also. Lordship will find at page 184.
The amount payment is something like so they are in that case the payment was deposited in the portal. They have not made the payment.
Mr. Buchan,
My lord,
your acquisition proceedings would lapse as a matter of fact.
my lord,
Have you examined that consequence?
no, my lord, with respect. Because,
It has lapsed. It can't be, now it can't be saved.
no, because we have already, my lord, completed the work, my lord.
Maybe
Yes.
without depositing the acquisition, the compensation in the court.
May I draw your lordship's attention to page 131, my lord, of the
Yes.
learned single judge's order, my lord, in the writ petition that was filed. It's 2 paras, my lord, I'll read. The order starts, my lord, at page 130, 30th March 2017, my lord. This was after, my lord, the reference case was rejected on the ground of limitation. My lord, may kindly come to page 131. The third
gentlemen,
para, my lord, the
We have
claimant of
put
say-
you a very simple question.
My lord,
How would your acquisition proceedings survive now? If you have not deposited the amount in terms of the draft award,
my lord, I will deposit it, my lord, I'll take instructions.
will deposit would not save it now, sir.
Because, my lord,
LARR Act now.
Lord, our whole case is, my lord, that these landowners do not exist. And the land that has been acquired, my lord, is much
You were
beyond.
supposed
They
to
have
deposit
existed.
it in the court. Disbursal was the task of the LAO, not your task.
My lord, that's what, my lord, page 131 clearly records the finding, my lord, at the last paragraph that we were never put on notice, my lord. The record was examined in the last paragraph, page
You did
131.
not challenge it, sir, on that ground.
And
My lord, all that I'm
Mr.
saying, my lord,
Counsel,
my lord,
this observation is only in reference, is in the reference
Reference
proceedings,
proceedings.
not before the deputy commissioner, not before the collector. This observation 20B will only come in a reference proceedings.
my lord, but 20B, my lord, no notice to EPIL while passing the award, my lord, page 131.
All right, will you admit your appeal? Admit issue notice. And counsel for Mr. Kalita appears for the state of Mizoram. Response numbers
Respondent number 1, 2, 3, 1, 2, and 3. Lordship.
1, 2, and 3. Counsel for the appellant to take steps for effecting service on the remaining respondents.
Number 4 is also represented, I think number 4 is represented.
4 also.
5 to 336.
Fake. They have no idea about legal service of the case. I had a conversation with the members. He's a big C. Yes.
My lord, through paper publication, my lord? Yes,
No, first you get them, try to get them served by regular process.
very well. Deeply obliged.
Obliged.
Dusty service.
Might be.
Rule is mandatory only 8 weeks. No, Dusty. 8 weeks. Steps within 7 days.
Obliged.
7 days bhi hoga nahi. 330 respondents. Steps to be taken within 3 weeks. The rule is mandatory only 8 weeks thereafter.
Item number 12.
Yes. You had filed as representation.
Lordship.
Should we direct the authorities to consider that first?
Lordship.
What else? Yeah, all questions of facts, basically.
Lordship.
So-called misappropriation. So let the principal secretary examine your representation.
Yes.
We'll dispose it now. Give him 4 months time, objectively consider and pass a reason. All right. The instant petition Article 226 of the Constitution. The petitioners have filed the instant petition under Article 226 of the Constitution of India, styling it to be a PIL with the following prayers. First up, the petitioners have alleged that before approaching this court, they submitted a detailed representation to the Principal Secretary, Government of Assam, on 21st March 23, but till date, no response has been forthcoming to the said representation. First up, in view of the submissions advanced at bar and considering the nature of allegations made out in the petition, we hereby direct that a fresh representation with a copy of this order, we hereby direct that the petitioners may submit a copy of the writ petition and the annexures with a copy of this order to the Principal Secretary within next 3 weeks. Full stop. Such documents, thereupon, the Principal Secretary shall treat the petition of the petitioners to be a representation and shall objectively examine the same and dispose the same of by a reasoned order within a period of 4 months from the date of submission thereof.
Although in the meantime, he always has the liberty to file a representation before the special vigilance cell in case he feels there has been.
The petitioners may also, if so desired, submit a representation to the special vigilance cell
of the chief ministers
of the chief constituted under the office of the chief minister, Assam. Post of such representation shall be objectively considered and disposed of by speaking orders. Post of, if in case, the allegations made by the petitioners are found substantiated, appropriate action shall be taken. Post of. Needless to say that if the petitioners are not satisfied with the outcome of the consideration so made, they shall be at liberty to avail suitable remedy for ventilating their grievances. The instant PIL is disposed of in these terms.
Lord.
Item number 13.
May it please your lordships. My lord, on the previous occasion, my lords had directed
tagging off for the records of writ petition 5.
That is here. Yes, read the writ petition.
My lord, that here.
There were submissions. You did not address them. So this is the res judicata.
My lord,
Stopped.
my lord, prayer did not have it. They were.
Prayer may not be, but there were assertions to this effect.
My lord,
Read 7.
In fact, my lord, if your lordship, yes, para 7 and then para 10.
10, yes.
Yes, para 10.
So you raise these submissions
Yes, my
in your petition,
My lord.
did not pursue it,
My lord.
withdrew it. Now you are stopped from raising the same arguments again, sir.
My lord, may I just make one small submission, my lord? My lord, here basically my writ petition that was filed previously, that was against the auction sale that I
Sir,
contended was.
whatever, gentlemen,
My
you
lord, I
are
understand.
all along canvassing a case
I
that
understand.
your movables have been seized along with your stock property.
I understand.
And you raised that grievance, gave it up. What can be done?
My lord, giving it up perhaps was not the exact position.
Precisely, you could have argued
A
that
different
subject
counsel
to
under what circumstance that was withdrawn, I don't know, but anyways, my lord, I leave it up to your lordship, my lord.
the petitioner has filed the instant writ petition under Article 2 to 6 of the Constitution of India, raising a grievance that while seizing the secured assets of the petitioner, in form of immovable property, the respondent bank, officials of the respondent bank, also took into possession certain movable assets about which, neither any inventory was prepared nor the same were handed back to the petitioner after the immovable property was sold. First off, we had directed the registrar to tag the file of the previous writ petition number 5244/2022, preferred by the petitioner in relation to the very same securitization proceeding on perusal of the pleadings of the said writ petition, which was withdrawn after advancing some arguments on which was disposed of as withdrawn, dismissed as withdrawn. After some arguments had been advanced on behalf of the petitioner by order dated 2/9/22, we find that in the said writ petition also, similar submissions have been made by the petitioner regarding possession and withholding of his movable assets. However, no effort was made by the petitioner to pursue this said prayer in the first round of litigation. Hence, the petitioner is stopped from raising the same plea again through this writ petition. Hence, the writ petition lacks merit and is dismissed as such.
Item number 14.
Provincialization. List before the provincialization bench. Next also. 14 also. 14 also will go to provincialization.
To provincialization bench of the.
They will.
16.
Item 14 is a separate matter, not.
Item?
provincialization. Item 14. matter.
14 is not a provincialization matter.
My lord, I have item 14.
15, you are on
14 is.
14 is provincialization.
Lordship, it is,
15
It is a provincialization matter.
Position.
Yes. So 14 provincialization, 15.
15, my lord, we have to
Also-
file our affidavit, my lord. It's a regular matter, my lord, not.
Okay,
provincialization.
15, Mr.
A week's
Mazumdar raised for and is granted 4 weeks time to file affidavit in opposition on behalf of the respondents.
Obliged.
The respondent already taken 3 times, my lord, taking.
Last opportunity is being granted for this purpose.
Obliged.
Item number 16.
High Court reply.
Lordship, the reply is ready, Lordship. We'll file it in the vacations. Let it come after.
Then counsel for the High Court states that the affidavit on behalf of the respondent is ready and will be filed during the summer vacations. list immediately after the summer vacations.
Item 17.
Much obliged. Nice.
17, my lord, we are in receipt of instructions. We'll put that on affidavit. My lord, we'll request some time.
Last chance had already been given.
My lord, there is a peculiar circumstances. The DFO which was handling the issues, my lord, there was an incident. Some persons were killed, so he was suspended and taken off session. New DFO has come in, my lord. So he has prepared
It
instructions and
is submitted that a new DFO has been appointed in the intervening period, and thus the affidavit on behalf of the respondents could not be filed. One more opportunity is granted to and counsel for the department, forest department, to file affidavit on within next 3 weeks, list of summer vacation. All right.
Item 18.
Yes.
Well, in this petition, my lord, the question is whether the public amenities available in the religious places or not.
So the affidavits have come in for all divisional commissioners?
All not, my lord. Half,
Not all. So
most
half are still pending.
Yeah.
So complete that exercise. Affidavits on behalf of divisional commissioners from some of the districts
Yeah.
are still awaited. The remaining affidavits we file shall be filed positively within next 6 weeks, list of 6 weeks.
Development.
Supplementary list, item 20.
Yes. And on last occasion, lordships wanted to go through that judgment, my lord. Basically, my lord, settlement was not given on 2 grounds, my lord. They're not in the neighborhood. And secondly, my lord, their list of villages are, my lord, not in accordance with the rules. Now, if your lordship would, basically, my lord, what had happened, and a complaint was filed by the appellant society before the deputy commissioner regarding they being in the neighborhood. And on the basis of the complaint, my lord, page 88 order was passed.
Yes.
If your lordship would kindly come to page 88, my lord. In fact, there was an order of this honorable court also. If your lordship would kindly come to the bottom, my lord, last 2 lines. The neighborhood certificate submitted by number 11 column, that is respondent number 10. In the tender papers bearing number dated so and so was examined, and the information provided to the certificate is incorrect, as none of the operational areas of the society is situated in the bank of the Kamrup River Brahmaputra Fishery jurisdiction. Majority of the members are shareholders and resides in Niz Govardhan, which is situated in the bank of the river Kolong, 1 kilometer distance from Pragdispur. So, my lord, we are concerned with this Kamrup River Brahmaputra Fishery. This is the Mahal, my lord, or the fishery. Now they live in, my lord, another jurisdiction. So therefore, my lord, this finding of fact, my lord, nobody had challenged. Based on this, my lord, the settlement was denied to them, though they are higher bidder. Amongst others, this was the ground. Now, my lord, the learned single judge relied upon the judgment. If your lordship would kindly come to page 154. Para 31, my lord. As regards the second ground, namely neighborhood, the finding arrived at in the impugn order is that majority of the shareholders of the petitioner society reside at village Niz Govardhan, which is situated at 1 kilometer distance from the fishery. The list of the members along with their address would show that other than the village Niz Govardhan, there are other villages also where the members of the petitioner society reside. The mere fact that certain members are residing at a distance of 1 kilometer
cannot govern the fate of the society. Further, the decisions relied upon by the petitioners have laid down in clear terms that while ascertaining the requirement of neighborhood, the same cannot be done with minute mathematical precision, and requirement is only that actual fishermen belonging to scheduled caste community residing in vicinity should get the benefit. In the opinion of this court, such requirement cannot be tested in the golden scale and would depend on the case-to-case basis. This court is in the humble agreement with the interpretation of the expression neighborhood in the context of Rule 12 made by Honorable Division Bench of this court in Brahmaputra Part 2 Mas Mahal. The relevant extract of which has already been quoted above in the judgment. This court is of the view that for the purpose of requirement is to advance the objective of the rule and not to frustrate the same. The Honorable Division Bench is also laid down the term neighborhood does not express any definite idea of distance. My lord, Brahmaputra Part 2 Fishery was a case where all the society were in the same neighborhood. Amongst them, the fight was, my lord. Kindly have the judgment, my lord.
Yes.
Book list condition, huh? My lord, 2003 1 GLT 155. Unlike in the present case, where they reside in another neighborhood, all the societies were in the same neighborhood. And it was a case of direct settlement, my lord, proviso to Rule 12. For the facts, please come to para 13, my lord. At pages may not tell you, my lord. Para turning to the aspect of neighborhood, we feel that the expression needs interpretation so as to advance the object and purpose of the rule and not to frustrate it. As observed earlier, in a given fact situation, there may be more than one society in the neighborhood of the fishery. It may so happen that society fulfilling the other conditions of the proviso and which is more deserving for such settlement is distance was slightly further away from the fishery than the other eligible society. Will the object and purpose of the proviso be served if former society is discarded only on the ground that though it is more deserving, the other society are nearer to the fishery? That is not the facts here, my lord. My lord will kindly come to their own certificate, my lord, which they annex in the writ petition at page number 65.
Yes.
Page 65. This is a type copy. The original is at page 66. I'll have your kind attention to second subpara. Society deserves settlement as all the members of the society are catching fish. In this connection, preference may be given as practicable to reorganize fishery cooperative society located in the neighborhood of the fish. That is number 25 deposition. That's the fishery. Then, my lord, second is so-and-so group of Molia group of fishery. The society applied for settlement in these areas. So they are in the neighborhood of this fishery. They are not in the neighborhood of Kamrup Brahmaputra River fishery.
Mr. Chaudhary, the learned single judge examined the list of members of this.
Yes.
Where is that?
Yes.
Is that list? Let's see.
Yes. My lord will kindly come to page 130 for a moment, my lord. 130.
130?
Yes.
Yes.
This is the information given by the circle officer. My lord, these are the villages. This is informed to the petitioner by the circle officer's office. Kindly appellant, my lord, with reference to the cited above, I have the honor to submit herewith the following list of villages from Mid Mahal, Kamrup, Rajjadishpur, Brahmaputra fishery in terms of distance in kilometer. Kindly see, my lord, Maloibari is 22 kilometer. Pub Maloibari is 24 kilometer. Amor Pothar is 15 kilometer. Deosal is 16 kilometer. From NC is 14 kilometer. Then my lord will kindly come to the next page. This is given by the Chandrapur circle officer. Kindly see, my lords, it is hereby certified the distance from Kamrup, Rajjadishpur, Brahmaputra, Min Mahal, that's the Min Mahal in question, to the following villages are mentioned below. Distance to
Dhomukar Kundo 18 kilometer, Dipuzizan 14 kilometer, distance from Komarpara 20 kilometer, Kamalpur 16 kilometer, Gobardhana Gaon 12 kilometer. I do not know where from this 1 kilometer has come, my lord. Now kindly come
That
to
was,
the list
that
of
was
members.
discerned from the list of members.
Yes. List of members is page 56. Sorry, 55, my lord. And you see they are belonging to Govardhan. That's already shown as 12 kilometers.
All from Govardhan.
Then my lord will kindly come to the next page.
Gormara, Janpam.
Gormara, Jampam. Then Nis Govardhan.
Yes.
Then Dipuji.
Digarmukh, Dipuji Janpam.
Dumang, Kalongpar.
There are other villages also.
Yes, my lord. Page 57.
Yes.
Posim Maloibari.
Malaybari. What is the distance?
I have already shown my lord. It's more, my
Dimaria.
lord.
Dimaria.
Dimoria.
Dimoria,
It's
yes.
all, well, they are in a different location altogether, my lord. I do not know where from this 1 kilometer thing has come. And my lord, that finding of fact arrived at by the deputy commissioner established, my lord, that has attained finality. And my lord, there is one more judgment, my lord. My lord, এখন দিয়ক না 1998 1 GLP. Forgive. Hello, there is one more judgment. It's a division bench judgment, my lord. The scope of interference in such matters is laid down, my lord. My lord will kindly come to para 20. Similar argument was advanced here, my lord. The learned judge, as rightly submitted by appellant's counsel, has approached the case from a wrong standpoint. So this was the submission. Then my lord will kindly come to para 27. The question of neighborhood and area of operation has been subject matter of debate and discussions in several judgments. And even the learned single judge has also made a reference to it towards the end of the judgment, indicating as to what is meant by neighborhood in the context of Rule 12. Without disputing the proposition here again, the question that falls for consideration is one of the extent and the scope of judicial review, whether this court in exercise of its power under Article 226 examine the question of neighborhood with such minute factual detail as to measure every inch of distance at which a society is situated. It is something to be measured in foot and inches. All that this court extending jurisdiction such an extent would be nothing but sort of being violent to Article 226 of the Constitution. All that the court can examine as to whether conditions and requirement of neighborhood as prescribed under the rule, it was present to the mind of the settling authority. So, my lord, as long as, my lord, the authority is alive,
1 kilometer, Mr. Chaudhary, comes from the order dated 23rd September.
True, my lord, but it is not in the same neighborhood. It is there in the neighborhood of another fishery. My lord, I'll give a little background, my lord. Now, my lord, the proviso to Rule 12.
Yes.
My lord, the idea of, my lord, earlier, my lord, there was no tender system. In a particular neighborhood, some societies are there. From time to time, they reorganize themselves also. Even, my lord, there is a full bench judgment of this honorable court in Aravinda Das, where this honorable court said, for achieving the objective of the rule, my lord, even government can forego, my lord, revenue also. All that, these people must be engaged. People who belong to scheduled caste,
Locality.
who are really fishing community, live in the neighborhood, they alone should be given the benefit. So idea is, my lord, they will earn their livelihood. Now, here is a case, my lord, they are in the neighborhood of another fishery.
Basically, this.
It's not, in Brahmaputra part 2 was concerned.
From here to down, distance is 12 kilometers. This scope of the is 12 kilometers. There is that list of various distances of the areas, Mahal,
Yes,
you pointed out,
yes,
please.
130 and 131, my lord.
130 and 130.
131.
Just. This seems to be actually incorrect. ये देखिए गोवर्धन गांव is 12 kilometers. 12. ठीक है ना? 19 को, हाँ. The society should be that in village Nisgo. Nisgo then is 12.
Yes, who is appearing for the government here? You see, this particular order dated 23/9/2019 refers to a particular village and says that it is 1 kilometer. Now, if you see the documents which the appellant have enclosed at page 131.
Yes.
There it has been shown at the serial number 5,
Govardhan Gaon 12 kilometers.
12 kilometers.
So
How do you explain this? Wow, on what basis did the additional deputy commissioner arrive at this particular mark?
can you explain, Mr.?
My lord, I'll explain.
Yes.
These are the villages, this does not fall our fishery. My fishery covering village, my lord, page 49.
49.
49, these are the villages. And that is, my lord, 131, it does not fall our fishery. My fishery falls, my lord.
No, Mr. Council, you see the order of the deputy commissioner, additional deputy commissioner, please see. Come to page 89 first. Majority of the society shareholders resides in Nij Govardhan. So Nij Govardhan is at about 12 kilometers,
No,
not
my
1
lord,
kilometer.
It is 12 kilometer, it is according to them, my lord. From their.
Not them, this is a certificate issued by the circle officer.
Circle officer in Govardhan, my lord. Nij Govardhan number.
So is
Govardhan,
Nij
my lord.
Govardhan and Govardhan Gaon different?
Different.
Are you sure?
Govardhan to, yes, my lord, from the certificate it will reveal, my lord.
Let's see, yes,
Page 49 be seen, my lord.
yes.
Distance
may
to
be-
Govardhan Gaon is 12.
Yes, 9.
And
So
our
Nij
is
Govardhan is a different village, Mr. Chaudhary.
No, my lord.
different village, my lord.
No, my lord will kindly come.
Nomenclature says so.
Eh?
Nomenclature says so.
My lord, can I just come in, my lord?
Yes,
Kindly-
yes.
If your lordship would kindly come to page number 50, my lord, this
Yes.
triggered the litigation. Please
Hmm.
come to page 50. Now,
My
this certificate was issued, kindly see, this is hereby certified that number 11, sorry, part so and so represented by Jagadish Burman is constituted by the neighborhood of so and so. Above certificate has been issued as per report of the Latmandal submitted as per application dated so and so. So, my lord, this triggered, then we filed to complain, my lord, that your lordship will find at page number it's 117 and my lord 118. 117, my lord.
Just.
6, sorry, 116.
Yes.
Then, my lord, the another one is at page 114. So these are the two complaints we filed. When they did not do anything, my lord, we filed a writ petition.
Okay.
That lordship will find at 117. And the
Examine the complaint disposed of by reason order.
Yes.
Then that reason order came into being.
Yes.
But the reason order says 1 kilometer only.
My lord, no, 1 kilometer, my lord, distance is not the matter. It says they are not, they
Not
are
in
in
the
the
locality.
neighborhood of Kolong, which Lanet Single Judge has not taken note of. Page 89, my lord, may kindly come. Kindly
Not
see,
in
my
the neighborhood of Kolong.
this is different. Kindly see, my lord, Bank of Kamrup, majority of shareholders in Nij Govardhan, situated in the bank of River Kolong. So we are concerned with, my lord, Kamrup Pragjudishwar Brahmaputra Min Mahal. That's the point.
Reaching to the areas. That becomes will come. We are offering them what? It's not a lot of money. It's something. Yes. Oh, who is operating the fishery right
As
now?
on date, we are doing, my lord.
Yes.
No, my lord, it has been cancelled.
As on date means what?
No,
Cancelled
on
means
date.
what? Cancel, when was the settlement made?
Settlement has been cancelled and we have.
Oh, just hold on, sir, hold on. When was the settlement made?
One second.
What is the date of the settlement?
Thank you, Timan.
Day before,
এটা নতুন settlement. Oh, it was it. No, বেলেগে আছে।
lordship, it has been done on
I'm coming.
Huh? 21, my lord. Lordship, can you have a look, my lord?
Yes,
I
yes.
have the-
On 21, fresh settlement order has been issued in their favor.
21 June.
June.
No, when was the original settlement made?
Original is earlier, my lord. Original settlement order is at কিনু বলে?
Lordship, all the picture will be clear from para 23, my lord. What is the
Page
record?
96.
Para 23, page.
Hold on,
151.
sir,
Page
hold on.
96, my lord. It is in 2019.
Just hold. 96.
Page 96.
Hmm.
18, 11, 19.
So it was settled in favor of the appellant.
Yes,
Okay.
that was interfered by the land.
By the learned judges. Yes, now what you want?
Lordship, kindly see page 151 at para 23 of the judgment, my lord.
Yes.
How the honorable single judge came to the finding, my lord, 1 kilometer odd distance. If your lordship permit me, I'll just read out, my lord, small.
Yes, yes, of course.
Para 23 at page 151. Mr. Sharma, so-and-so government advocate Assam submits that the imping order contains reason and therefore no interference may be made. Mr. Sharma has however candidly and fairly submitted that actual fisherman certificate in favor of petitioner number was concerned, ACS was available in record. By referring to the record in original learned state also made a stating revelation that as per the report of circle officer, recommendation to settle was actually in favor of the.
Where is that order? That order is not a part of record.
Original record, my lord.
Oh, but that, it should have been brought on record then.
My lord, that we cannot get.
Final settlement has been made in
Record
favor of
was-
the appellant.
Record was produced in original. Record was produced in original. In
Yes.
division of circle officer report, my lord, they are the lowest, my lord, 38 lakhs and I offered 60 lakhs.
So, Mr. Chaudhary, the ultimate objective is not of money.
My lord.
It's of providing livelihood to the people in the locality.
Yes, my lord. I have annexed, my lord, my certificate, my lord, my learned senior counsel has not relied on those two certificates. Lordship, kindly have a look at page 52.
Yes.
Page 52. It is hereby certified that the Kalang Nadi mean Samavai Samiti is represented by secretary by so and so. Above certificate is issued in favor of so and so, submitted application dated so and so. Thereafter.
2012, they
Yes,
made
my
a complaint about it. Then a
My lord.
speaking order was passed.
Yes,
Have you
my-
challenged that, sir?
I have challenged.
Where is that challenge? Let us see. Have you challenged that order of 2019? The speaking order?
Yes, yes.
Let us see your prayer.
Subsequent read petition.
Which one?
In the common order has been passed. Two read petition I have filed. That has been set aside, my lord.
That was purely a question of fact, brother.
We are not party to that litigation.
Hmm?
We have not been made party in that litigation. In the second request which my learned friend is saying.
Lordship, kindly see page 141, my lord. Who was
Yes.
the party?
141.
141.
Did you implead them as a party in that writ
Yes, my
petition?
lord, Jagadish Burman, so and so.
Mr. Counsel, did you implead them as a party in that writ petition?
Yes, yes.
Are you
Reference
sure?
Number 10, it is there in the copy.
First title, let us see.
Yes, yes.
The writ petition number is?
140, page 142.
I'm sorry, my lord, it was my,
You were impleaded.
yeah,
You were impleaded.
my friend.
He contested, my lord.
Yes, yes.
After that, my lord, the honorable.
Let us see the finding ultimately.
Lord.
Settlement made in your favor. What about that speaking order?
No, not been interfered.
That order has not been interfered with. Read the finding.
Lord.
23,919. Where is the interference in that order? So these are contradictory order findings then.
My lord, I'm coming to this.
Yes, please.
Respondent number contended that the imping action is the taking into consideration in the neighborhood of the sexual matter when it has been disqualified as the certificate regarding the neighborhood of the fishery. Para 7 is the contention, my lord, certificate regarding the neighborhood of the community as a list of members society has been concerned. Thereafter, notice in the tender the order passed at the stage. Para 10, then additional deputy commissioner.
Sir, will you read that finding wherein
Yes, I'm coming.
23,919 has been reversed?
My lord, para 12 is the sealing the opposite order.
Yes, we see
Sealing
that.
the
We see
order
that.
And also against the remarks made in the comparative statement, the read petitioner has instituted fast read. petition,
Simple
which is
questions
number-
are again.
Yes, my lord.
Where is
I'm
the
coming.
finding, please?
Yes, I'm coming in.
Yes, come.
Para 13, my lord.
Yes, that is the finding.
My lord, I'm
Para
coming.
13.
Yes, I'm coming, my lord.
Conclusions, please, conclusions.
Mr. Petitioner submitted the unity not an absolutely unreasonable and very.
Hmm.
Projection, there are 21 the concept of the registered person. Dealing with the certificate of origin. There are 23, 24,
That we are located within another fishery zone. That is what the majority.
My lord, there are 30, it has been held, my lord.
Situated in bank of river column. Is at a distance of 1 kilometer. Not the fishery, which is situated in the bank of river column. It's a different fisheries. So they will be entitled to claim in that. The itself is divided in sections. For different sections, there will be different sections. That's what this is. Yes, where is the finding regarding that order, sir?
My lord, para
We tried to find it out, could not do so.
My lord, I tried to, my lord, para 30, it is written like this, my lord, the bid of the, my bid was cancelled only on 2 grounds.
Yes,
Firstly, my lord.
there was a complaint regarding your neighborhood certificates,
Yes, my
which
lord.
has been decided in favor of the plan by a speaking order. That order is not reversed. So there are contradictory findings in the judgment of the single bench.
My lord, one more thing, my lord.
Yes.
Lordship will see, my lord, there is a certain certificate, para 30, it has been held, my lord.
Hmm.
Then, my lord, para 31 also it raised about the neighborhood findings, my lord. Arrived at the imping order is majority so.
Yes.
Then lordship will see para 34, records contained from the report of the certificate. Recommended the settlement in favor of the whose bid is highest, not to speak about the assailing the any reason of discarding.
Mr. Borgoya.
Government has.
Mr. Borgoya, Chief Justice has put a specific question to you. You see, what the single judge has done is that relied upon that very order and held that it is 1 kilometer. And being 1 kilometer, it is within the neighborhood. And therefore did not set aside that order. there was a specific argument being made on behalf of the respondents here, the writ appellants, that there were various other distances. On the other hand, the 11th single judge has categorically held that when you are holding at 1 kilometer, why should we look into the other aspects of the
My
matter?
lord, since my lord, that point, my lord, I'll
Therefore, that
clarify, my lord.
order of 1811, that order of 23/9/2019 has not been interfered with.
But my lord, whatever the conversation or order reflects, my lord, it has been interfered. In other words, my lord, what did not assign my
That-
lord settings?
Then, Mr. Borbue, it makes the case fit for admission. Then there is a arguable point in favor of the appellants. All right, admit issue notice. There shall be a stay on the impure order of such.
My lord, I have deposited. my
You
lord,
will
my
get it
amount,
back,
my lord.
the amount deposited, if any, by the respondent towards settlement
And his
made
settlement
as a
is also being
consequence.
cancelled, my lord.
Settlement made as a consequence of the order passed by single bench shall be reimbursed to such respondent.
My lord, it has been cancelled also there, my lord, then
So
it.
that will be restored by stay. Yes, staying effect and operation. The effect and operation is stayed as a consequence. The settlement made in favor of the appellant shall, by order dated so and so, shall stand restored.
Item 21.
We'll pass a reason or detail on.
Lord, I have taken the, I have taken the instruction, Lord. Lord, I am told that all of them are belong to Punjab, my Lord.
So
The state of Punjab, they have detained them. And my Lord, already.
detention orders by state of Punjab.
By state of Punjab, my Lord.
Okay, very well.
And my Lord, this is the communication person to which they were lodged here.
Let's see. Call it the status report of detainees lodged in various prisons across the state of, in these jails across state of Assam has been placed on record. The status report would indicate that the state authorities are in the process of making requisite compliances in terms of this court's order.
Correct.
Thus, the proceedings are closed. We need to advise them, these guys will come out.
Lordship,
The
already,
orders have not been confirmed.
already they have communicated, my Lord, Lordship.
And
In respect of others, they are.
those are very serious facts.
Correct. my Lord.
So that is national security at stake. Maybe that those challenges might be in Punjab, for all we know.
There may be, my Lord.
Yes.
Lordship. Of Lord.
Item number 22.
May it be your lordship.
I have not read this file. You read it? I have not read this file. You know, are you? Put a query and dispose it on. Oh, yes, now I recollect, It's a false affidavit. False affidavit. Read this one. Read paragraph 42. It's a false affidavit. They were not even born. Yes.
My lord, here on this simple issue, my lord, what happened, my lord?
Come to page 47.
My lord. My lord.
When did the respondents, the original tenants, so-called original tenants expire?
Yes, my lord, but we are the, my lord, we inherited the property, my lord.
Oh.
Mr. Counsel, you come to page 35.
My lord.
Isn't this the representation given by the husband of the petitioner or the writ appellant? And this was in the year 2003. he was refused and said that you are going to have the room number 100, not 135. And thereafter, you have approached in the year 2022. How do you explain this delay? See the last 3 lines of this representation.
Yes, my lord, what happened, my lord? The room number 100 was allotted to us, we are continuing, my lord. Subsequent, but actually they had taken money. Actually, they have allotted room number 134, that is in ground floor.
You have approached after 17, 18 years. Where is your explanation? There's nothing out there in your petition or even in your affidavit and reply. There's nothing.
That is true, my lord, but when the landed property, my lord, sometimes it continues in the name of the legal predecessors, my lord.
Dismiss. Dismiss.
Listen.
He's here. Would you be appearing on behalf of the Election Commission?
Yes, madam.
All right, so Ms. Dubey's name has already been mentioned.
Respond number 8 and 9.
Item number 23.
Yes, Mr. PSGI, what is your?
Lordship, perhaps this bench may not like to take up because perhaps this bench may not like to take up because I have relied upon some order passed by.
That doesn't make any difference.
Then it's all right.
Relying on some order, that doesn't make any difference.
No, just-
While sitting in division bench, we can take a different view from our own judgment in the single bench.
Then that's.
That is quite possible. Where is CMA council? So Goswami was there.
Junior was there.
There she is.
She's good.
Yes, madam, your case is taken. Yes.
Now, here is a lordship case where the appellants seek a lordship renewal of their earlier term. Now, yes, as I had pointed out, lordship, in the meantime, the catering policy of 2017 had come.
That's
into
what was
force.
pointed out
They-
the other day. That was what was pointed out.
on-
That the license is issued prior to coming into
Yes,
force of the
yes,
catering
yes.
policy.
Now, that was issued, let us assume, lordship, in 2014, that was in terms of the policy of 2010.
2010, yes,
2010.
yes. So 2010, did it have any renewal clause?
Yes, it did have for a period of 5 years.
5 years
5
only.
years, and that 5 years is completed.
How? 2014, the license was issued.
2014, the license was.
So for what was the initial period? Ms. Chaudhary, what was the initial period of license? What is the tenure of the license? Original license?
It is not, it is the original one.
For?
From the 2018 lordship till 2023.
So that would be 4 years only.
It has been given effect from 2017 because they were already there. Lordship.
The extension. We are asking you, you are saying that one extension has already been given. When?
No, lordship, it was settled in 2018, given effect from 2017 lordship. And if we read.
So the initial issuance of license as per you was in 17.
Was in.
Application
17,
was in 14.
That was in 14.
Okay.
That is why it will be covered under the 2010 policy. 2010 policy was in force till 2017.
Yes, all right.
So
So that is what they are trying to say,
Yes.
that there is a renewal clause in the policy of 2010.
Yes, I'm just taking a lordship to that.
Yes.
Lordship, the catering policy 2010 is annexed at page 109.
109.
109. And
Mr. Goswami,
Yes.
perhaps you should argue it after vacations. Because Lordship has taken a different view.
Okay.
So it will be advisable that you, Mr. Goswami, Senior Counsel, Mr. Goswami, praise for time, list after summer vacation.
Item number 24.
Yes.
As per Lordship's direction, Lordship, we have received the reports and accordingly, Lordship, we have put it by way of affidavit. Lordship. It is in
You have filed it already
Lordship, we have filed it on the
on
report.
23rd June.
Lordship.
Yes. You have received it? Mr.
Yes,
Chaudhary?
yes, yes, copy has been given to us, my lord.
Okay.
But the affidavit does not reveal any such thing, my lord. They refer to a particular advertisement and there was a court stay order. That's why they could not proceed.
Hmm.
My lord, I had a very small point, my lord. Whether this power can be exercised by invoking proviso to 309.
Hmm.
I'm not saying state cannot do it, my lord.
Mhm.
State can do it under proviso to 323.
Yes.
And secondly, my lord, in an administrative exigency, maybe from case to case, it can be done. But altogether, my lord, taking out from the
Mr. Chaudhary,
purview of
practically,
APSC, that's an issue
we-
I have it needs consideration, my lord.
practically, if we see the APS, this APDC, what the survey, this commission has hardly been able to do anything. Strife in controversies, litigation, scams. So how?
Yes, it is.
What to
There,
do?
but I think
Then
from
are these
2014,
services
I think
to be
2014
compromised in this manner?
2016 things have changed, my lord. Entire setup has been changed. 2016, my
still.
lord, after coming of the new government, my lord, whole setup has been changed.
129.
My lord, the whole issue is, my lord, whether in this way the efficacy of Public Service Commission.
Shall I
can
read
be-
para 5 of their affidavit?
Yes.
So are we to compromise the cadre strength of the departments?
No.
Simply because the APSC is not in a position to do so.
No,
So the state should not adopt any
no,
proper measures, fill in the posts.
my lord.
Is
my
it,
lord,
that is the
My lord, what-
ideal situation?
My lord, okay, I have come prepared, my lord.
Hmm.
Please come to para 5.
Yes,
That
we are
the
reading that.
deponent begs to state
Hmm.
that by letter dated 24/4/19, Assam Public Service Commission informed the Higher Education Technical Department that despite the best effort, the commission is not receiving good response from technical and non-technical faculties of the college in respect of setting up question papers and requested department to issue necessary instruction to the concerned authorities. In the meantime, APSC conducted this training test for recruitment to the post of assistant professor. Thereafter, Assam Public Service Commission, by letter dated 7/3/2020, requested the department for deputation of representatives for discussion regarding specialization, particularly in respect of ME, MTech in connection with the said advertisement. But in the meantime, some candidates filed a writ petition before this honorable court, being WPC number so and so.
Mr. Chaudhary, para 6, APSC has thrown in the towel.
Malad, the department said as per the efforts between the Assam Public Commission. No, Malad, under this new regime also same is this situation. Kindly come to the regulation, my lord. Kindly come to the regulation.
Yes.
At page number 77, my lord.
So at least they will be making some kind of new attempt at least. That's what we can say. 77, what is it?
My lord will kindly come to page 83.
Yes. Board.
Please come to 3.
Uh,
In making recruitment to technical specialist post, board will invite the appointing authority to depute technical experts. Same thing, my lord. Even they will also do the same thing. But lord, APSC cannot bind anybody to come to, this is the government who has to, I mean,
So now
direct them.
at least the government has some say in this board at least. The board is just
They are
an
going-
extension of the government,
Extension of the government.
virtually. So you can expect some better things by that.
Kindly come to 4 also, my lord. In any
All right,
case,
we'll admit your petition for academic exercise. What else? Admit issue notice. List for hearing in due course.